Hi, I'm Chris Colvin. I'm the founder of PARC, and we're an organization for in-house counsel, outside counsel, and legal technologists who want to network with each other and help each other be successful. And we really believe that to be a successful legal professional these days, you really need to network with all three categories. So the clients in-house that work directly for the companies, outside counsel, and the legal technology providers. If you don't have robust connections in all three areas, we think you're really missing out on opportunities to educate yourself and do a better job serving the corporate community. So I'm here with Dave Stevens, who's a longtime IP lawyer, been practicing for decades as I have. I've been a little more of a IP litigator. Dave's been a little more of an IP prosecutor, but we both do both to some extent in terms of the clients we serve. And we also have a very strong in-house perspective. I've been serving as an outside general counsel for startup companies for over 20 years now, on and off. And I've had dozens of those types of arrangements. And Dave also has a very strong in-house perspective, and also is an investor and does all kinds of amazing things as a business person, not just as a lawyer. So I thought I'd introduce today's session or frame it by just unpacking two common terms that lawyers throw around all the time, but maybe we don't stop to think about that much. The first one is risk management, and the second one is intellectual property. And let me unpack briefly risk management. So risk, as you all know, there's upside risk and there's downside risk. Upside risk is how do we use the law to help our clients, whether they're internal clients or external clients, to maximize the revenue that they generate through their use of the law. And of course, downside risk is avoiding losses to the extent you can do that as a lawyer using the law. I think we spend a lot of time on the downside risk piece, and I think lawyers need to spend more time on the upside thinking about that. And the management piece is what? We're in charge. We're the managers. We're in charge of using the law to manage both upside risk and downside risk. That means we can live on the revenue side and not just the cost side of the business, right? So that's important. Intellectual property is also a term we use all the time without thinking about it. But for me, it still blows my mind after doing this for more than 26 years. We can use our minds to generate value, to generate an incredibly valuable asset. And that's really what intellectual property literally means. And it's what we can do with that. So whether you're in-house or whether you're outside counsel, make sure you remember that the power of IP. And I know during the course of my career, it's gone from kind of a backwater to the central asset for most companies. It's really the most valuable part of most companies' asset classes, right? Think about what Google would be worth, or Facebook, if they didn't have access to IP protection. You know, Google is a great example because if you just took away their name, that's one piece of IP, right? Just their trademark in their name. I think you can make a good case. I'm no economist, but you can make a good case that they'd lose half of their market value just because they were deprived of the use of their name, because it's so tied up in what that company does and what they're worth. So, you know, it's a really important, these are really important concepts, and I think it's a good way to frame the discussion today. So Dave, I want to give you an opportunity to introduce yourself, and then we'll jump into the PowerPoint. But tell us a little bit about you and your practice.
Yeah, thanks, Chris. Yeah, so yeah, I've been practicing in Silicon Valley for about my whole career, just about 30 years. I work primarily with startups. I also have my anchor clients, like most do, you know, Ford Motor Company and Walmart. I've built their portfolios from nothing. And startups, it's interesting. They're just different scales, but they have the same issues. Nobody likes to spend too much money on IP, whether you're a big company or a small company. And it really can be a strategic asset. And I would add one more thing that would like a corollary to his definition, to Chris's definition, is that it's really about the people. It is the one thing that your employees, that your client's employees can point to that certifies that they did something, they created something that's never been done before. And there's nothing better on a resume. I mean, yeah, you've got, you know, degrees, you got all this hard work, but listing something that you created that's never been done before, some kind of improvement on something, is pretty amazing. And there's nothing more motivating than that kind of certification to an engineer, young or old. It's really something. And it's not just this resume builder. It's something that really drives their career, just like it can drive your business. So it could be, yeah, not to overextend it, but it's really, it's something that is really great for an HR vehicle as well as building an asset for the company.
No, I couldn't agree more. My dad was the leading oncologist, and one of the things that really excited him was he had some patents, and he was so excited about it. I'm like, Dad, but you've saved thousands, maybe tens or hundreds of thousands of lives through your research, but he's like, oh yeah, but I had a patent too. So people do get excited about it. So let's dive in, Dave. Let's dive into this. And again, if you just joined, feel free to ask questions in the chat window, or you can unmute yourself and ask a question if you'd like as well. So let's dive right into this. So this is a GC's guide to IP strategy. So we're really trying to take the in-house perspective here, although obviously we welcome discussion from outside counsel as well. So please feel free to chime in. So Dave, why don't you take the first slide that's sort of a bit of an overview.
Yeah, so the goal, and this is a phrase you can use even in your own legal disciplines, to be a sophisticated consumer of IP services. I mean, if you're really serving your clients and you really want to be that trusted outside counsel, I think it's a great phrase to use, and it's a great mantra. And we can help them do this and hire us and work with us and get that assurance that they understand the value of what they're getting. Too many general counsels, I got to say, very widespread even nowadays, is that they just don't understand IP enough to understand the services that they're getting. The quality of a patent or a trademark or whatever work that's getting done, they just have this outside trust, which you want that. But the more you understand about it, the more you can advise the C-suite of, hey, look why we're doing this. Here's a strategic asset. This isn't just like on the shelf as an insurance policy. So becoming a strategic expert in IP development and setting budgets based on the ongoing IP strategy, the GC can do this. They can help do both of these things and be that strategic advisor, not just the C-suite's a client of yours and you're performing services. No, you can help drive this. And these two images, this is from the closed innovation, open innovation world, the Chesborough stuff. And I like to include it because it's a pretty decent illustration of where intellectual property comes and goes in a company. Closed innovation is, you think about like military contractors and things where everything's very secret, right? And everything's invented here and it's kept here and it's kept secret here. And that's the old kind of corporation. Open innovation, you realize that innovation comes and goes through many different facets. And I've helped clients actually do visuals of their own company showing where the IP actually comes and goes on a regular basis. You have vendors coming in and providing things, doing services and building things that are better at building things than you are. And you incorporate them into your services and even into your products. And sometimes you'll develop some kind of thing like a docketing system, maybe in the legal department. In fact, Ford Motor Company did this with British American Tobacco. They didn't like any of the docketing systems that were out there. They built their own. It was amazing. They spun it out as a separate company and made a lot of money. I mean, out of an auto company and a cigarette company, for God's sake. They created this thing that now many large companies, if not all of them, use this. It's called an aqua, right? So these are types of things where intellectual property can have so many different places in the company, used as a strategic asset, and can even make money separately on its own. So I like this visual, and it's good to adopt some type of visual like that for your company so you can get that feel for what intellectual property is doing for the company. And it really helps, these visuals help the officers who have no clue about intellectual property. It's so complex and everything, simplifying this and understanding that this is where value flows in and out of the company.
Great. All I would add on this slide is if you're a GC or another in-house lawyer, you're actually more than a consumer of IP services. You're a partner. In fact, you're the senior partner in this enterprise. The outside firm is working for you. You're the buy side. So treat them like you're the senior partner because you are. Now, they may know more. GCs may never know as much as Dave Stevens about IP, but he's a strategic resource to them to learn what they need to know to translate this into the value that IP brings to the company. And that, therefore, someone like Dave can empower the GC or the chief IP officer or whoever the in-house contact is to really show their value, show the value that legal brings to the table, especially IP legal. So Dave, I think this is for you again.
Yeah, so there's three pillars of sustainable innovation culture, right? And we talk about this in open innovation. Open innovation is something that's being integrated into the big, old, dusty companies that are trying to understand and leverage their IP and their ideas, their secrets, and also outside providers. And building a culture of innovation is something that a GC can promote to help build these assets, build them in a sensible manner, not overspend, not overbuild, but build it in a smart manner that everybody understands from their perspective, the engineer's perspective. They understand why they're developing intellectual property. They understand why you're protecting it. They understand why you're keeping things secret and not publishing them as patents. And from the C-suite, they want to understand not just, you know, how you're covering things and why, but how they can use these assets in things like negotiations with other companies, competitors, vendors, customers, right? These things can really identify and protect things that are unique, and you could use them in negotiations to win as bargaining chips, to win great value. Budgeting protection of valuable ideas with intellectual property, and that's really what it's all about. Keeping the budget under wraps, but justifying every nickel and showing how you've leveraged enough so that you get really some type of return of investment on every nickel that you spend on your intellectual property.
Couldn't agree more. I've had presentations where I use ROIP, return on IP, to remind people that when you invest money in IP, you should be getting a return.
It's a great one. Yeah.
So I guess I'll start with this one. So just elaborating a bit on Dave's idea of culture of innovation. Really, you do need to take a holistic approach. And that's why it's sort of appropriate to start with a term like culture, which maybe can sound wishy-washy, but it's really not. It just means that one of your jobs as the lawyer, whether you're in-house or supporting an in-house legal department from the perch on a law firm, is you're helping the entire company really to be aware of IP and know all the different forms of IP that exist. One image I love, I learned this actually in law school. Justice Cardozo used this concept of a bundle of sticks and applied it to IP. And it's really a good one. I don't know who I remember being a Boy Scout. If you pick up one dry stick off the ground, you can just snap it like it's nothing. If you grab a whole bundle, I don't care if you're, the Hulk, you can't break that thing, right? You have a whole bundle of these rights. And companies should be thinking holistically to have a whole bundle of rights of IP, not just patents, but trademarks and copyrights and trade secrets and trade dress and all the different forms of IP that exist. So, and if you're not familiar with that as an in-house counsel, leverage your outside counsel to help you. And really, they should be offering their non-billable time. Go have a drink with them and talk to them about your holistic approach, right? Dave has a great idea of, buy your outside counsel dinner, right? And take them to dinner. They're probably not going to charge you for that couple of hours, right? And you'll get to know each other better, and you'll learn a lot. So always look for creative and innovative IP counsel, whether you're hiring someone new for your in-house team or hiring outside counsel. I mean, what is the point of having someone who's in the innovation business who's not innovative themselves, right? So you really want to be looking for innovative IP counsel, right? The days, I think, are gone where you can just sort of meet with the engineers, take down what they're saying and convert that into a patent. That is really not going to cut it these days. I often think that over the course of my career, I'm probably an unnamed inventor on lots of patents, and that's okay with me because I'm helping my clients to develop ideas and expand beyond the obvious initial thoughts and really get a robust set of IP protections in place. So again, you're the buy side if you're in-house, right? You're the boss. You're funding this whole enterprise. Outside counsel at firms, legal technology providers, we literally would not exist without the GCs and other in-house counsel. So remember that, right? And use that. You have a bully pulpit, you should use it. And you owe that to your company to really squeeze as much juice out of those outside counsel lemons and legal tech lemons as you can.
Yeah, you know, I was in a webinar last year to that point, Chris, and generally, it's funny because one of the general counsels in this breakout room said, you know, you're a pretty unusual attorney, and she didn't mean that to be insulting, right? She said you're giving us advice that goes against your interests, which means, so she said we can hire a patent attorney, trademark attorney, that will file anything we let them, right? Just patent everything you have, right? But what they want is the strategic advice that will help them advise the CEO. Why are we doing this, right? I just had a portfolio of patents transferred from a new client, and I looked at these things, and bundled in these patent applications were all of their trade secrets mixed with the non-trade secret, the stuff that you can see. Trade secrets, by the way, in technology are things you can't tell people are using them. So if you have infringers out there of these things, you can't tell because you just can't see it. It happens at the back end. You don't patent those things. You don't patent those things because they publish. And if you have claims that read on those things, you'll never see if anybody's infringing, right? And I talk people out of filing more patent applications than I talk them into filing applications, because you have to keep that in mind. You don't spill out your trade secrets, and you'll never be able to have practical application. So there's an example of the advice you give to the GC, they take to the CEO, and they're like, wow, that makes perfect sense. I never thought of that. But if you just load it onto a patent attorney who doesn't have this world view, then they're going to publish everything, right? They'll file everything. So what you want to do, and what I do also as the outside counsel, is to be that advisor, give that free call, talk about strategy. Here's what you should do. Here's your trade secrets. Here's everything else. Budgets aren't what they used to be, by the way. So you want to be more strategic with trade secrets. You want to record them. You have to do that. Have, you know, verifiable timestamps on them. And that's how you look at things holistically. And when they hear that, when they understand that, they're like, I feel cared for, right? I feel really cared for, and they're helping me be strategic and smart about every nickel that I'm spending.
Absolutely. Yeah. And by the way, I hope it's in the long-term interest of in-house counsel to show that value by, and hopefully get loyalty in return from the in-house counsel that are hiring them. So it really does pay off in the long run to have a deep trusting partnership with your in-house clients. So remember also, if you're an in-house lawyer, I really think, try to think proactively and not reactively about intellectual property. So I think there's this tendency to think that the engineers and scientists are inventing things or creating other IP, or creatives are creating IP in the form of copyrights, for example. However, you know, and then the lawyer just comes in and kind of records it, right? That's not really the case. Really, you need to go out and search for it actively, right? And I really do think of intellectual property as kind of buried treasure. And the only thing that shines a light onto that buried treasure is the law, or the IP laws. So if you understand the IP laws and understand how they work to find and protect and monetize that treasure, you know, basically the lawyer gets this rare opportunity to be the hero of the story, and it's a revenue side story, not just a cost story. So Dave puts in here wise financial constraint. Absolutely, you can't, you know, all this you need to subject to the rule of reason, right? You can't just if you file every non-obvious idea, if you filed a patent on it, you know, you could quickly exceed your IP budget. So you have to use judgment, not just creativity. One last thing I wanted to emphasize is this can be really fun. I mean, I've been doing this for 26.5 years, and I still love it. Intellectual property is an amazing tool. It drives our economy, and it's fun. So it's not, you know, it's not against the law for lawyers to have fun in their careers. And I think IP is one way to do that.
That's a great point, Chris. Well, Roger has a question, by the way, that dovetails
absolutely
well into protecting valuable ideas. And he's asking, Dave, are you confirming that the trade secret should never be registered as a patent? Then what will be the best suitable protection method? So trade secrets should be recorded internally. You need verifiable timestamps. Now, a lot of software companies have ways of storing and recording things with stamps. An email would work. Internal, you know, send an email to yourself, right? Don't mail things to yourself. That's an old myth. Don't send it to the US Post Office. Send an email to yourself, you get a timestamp. The reason you do that is because if anybody leaves the company and there's a trade secret misappropriation or somebody hacks in and gets it, you have to prove that you had possession of that trade secret before it was allegedly taken. And there's a famous, well, there's a case ongoing right now with a famous company, Palantir, where a board director, I'm not kidding you, an advisor of the company was inside, borrowed an idea, filed a patent by himself. When it published, oh my God, Palantir couldn't believe it. They kicked him off the board. They sued him for trade secret theft. One day they were in front of a judge in DC, and they had to prove that they had possession of this trade secret. And what do you know? They didn't have it. It was talk. It was in a meeting. No one recorded it. No dates. No nothing. And it's an ongoing battle that's working in the essentially the thieves' failure. So that's all I'm going to say about trade secrets here. There's a lot to talk about, but when you set up the system, it costs essentially zero because you're not paying me to do it. And maybe that's why patent attorneys don't talk about it much. but internally, this is the thing of value. This is the thing of value that you can build internally, and it perpetuates. And trade secrets are as valuable as patents. They are as valuable in different circumstances. They're super, super valuable. And again, talk about return on investment. You know, a nickel here and a nickel there to record your trade secret of your time, and you've got a valuable asset for the company right there.
Absolutely, yeah, and it's something to talk to your outside experts about, or if you have a robust in-house IP team, they can help you decide what should be protected as a trade secret and what should be filed as a patent. It's not like there's never any overlap there. Sometimes if you're in an industry where trade secrets will inevitably be found out anyway, you might be better off protecting them via patent. So there is a nuance there. But I agree with Dave that trade secrets are probably the most undervalued IP out there. I would maybe throw in trademarks too, because people do not realize the incredible value that's tied up in the names of their businesses and their products, and how that's an extremely valuable strategic asset. So on this slide, we've covered, I think, a bunch of this already just in our discussion. So I want to sort of go quickly, but one thing I do want to reiterate is, do not buy into this idea that in-house lawyers are just a cost center. I still hear that. And I get a little upset when I hear that, because I think it's patently false. So I'm sorry for the bad IP pun. It's just not true. Lawyers are a strategic resource, and they can help the company make more money. And IP is a great way to do this. So somebody needs to be the one to find and catalog and monetize these IP assets. Why not you? You're not disqualified from doing that because you're a lawyer, and you're not disqualified from that if you happen not to have a technical degree. You can educate yourself on IP law, and you really can be the person that's being proactive. And frankly, the engineers will thank you, right? They want to spend time geeking out on the technical stuff. They don't really want to spend time cataloging all these inventions and other IP they're generating. So you step in and be proactive, and you can really benefit yourself. It can help you have a very successful career. And by the way, if you're outside, how great would it be for your career if you try to help your clients really be the heroes to their management by helping them better manage their IP? So I think there's a real opportunity whether you're in-house or outside. So
yeah, a good example of, creating value. I mean, you're protecting your own products, you're selling your products. The companies, they think it's a bit perverse to license that IP to competitors. Like, wait a minute, that's why we have these secrets and patents, right? But you can develop things that are outside your space that can draw revenue. And one example is Hewlett-Packard. Everybody's familiar with their inkjets. They were the first, right? Amazing things that they did. Well, they filed some patents. So they asked the engineers, they said, what else can this thing be used for? This is precise placement of a chemical in certain places at certain times. And what they developed was something that was useful to the automotive industry for fuel injection. And they've developed this whole suite of patents that said, why don't we just apply it here? How do we do this? They learned something about engines. These guys, this was like candy to them. They had so much fun doing this outside. They already built the inkjet. They love cars. They were doing this thing with cars. They made millions in licensing fees for Hewlett-Packard to these automotive industry who do nothing about placement of chemicals and fuel injection. It was great.
Absolutely. And one famous counter example to that is the Xerox Research PARC story that you guys have probably heard of. But they invented a lot of the core technology around what Apple later used to become the largest and most successful company in the world. And they largely failed to protect any of it through IP. So, I mean, I'm exaggerating a little bit, but basically Steve Jobs walked in there and took all these ideas and built an incredibly successful company. So, there's also a danger of not. There's a positive side to protecting IP, but there's a huge risk in not protecting IP. So Dave, why don't you take this one?
Yeah, leveraging IP to lead markets. And a couple of questions that just popped in are right on point. You guys must be reading our minds. Either that or they've got a copy of this slide they're looking at. So one of the questions is, what's the best way to catalog things? We're talking spreadsheets and things. Yeah, that's a great way to catalog things. Trade secrets, though, you need a verifiable timestamp. It's the only one you need to do that with. So you want to have a timestamp. You do that. There's different types of applications. WIPO, it's a World IP organization, has a system where you can upload your trade secret, and it's kept secret, and it's a verifiable timestamp. It's kind of like filing a provisional patent application that never gets published. In fact, you could file a provisional patent application and never convert it. It just stays as a secret to a non-provisional application, right? So that's the way to record trade secrets. So be careful about that. But cataloging everything else, when I get startup companies with their first group of patents and ideas and technology things, we come up with a list and we just start P001, P002. We list them all. Actually, it's D because it's a disclosure. And you'll decide which ones are you going to file a patent on, which ones are you going to keep trade secret. And you move the patent ones to another column with P001, you file patents, right? So there you have a list of things. You have timestamps of when they were submitted and all those different things. That's how you catalog these things. When it gets bigger, or when you want some more organization, there are docketing programs. Now, your outside law firm, including us, we have docketing systems. We can give you a window into your list. So you're jumping into our software program and you're seeing your list as it grows. So another good way, Google Docs is actually great because it gives you a list that you could share amongst yourselves. But again, as a big company, you want something a little more orderly, right? But that's how you record these things. The other question was, is it a good reason for companies to use outside technical development research because it would create more records of development and documentation of creation of trade secrets and patents and things like that too. So you would want contracts with these outside technical entities so they're obligated to assign inventions to your company. Very important, right? I will say two things about this. Yes, it's a great idea. It's a great thing to manage. If you're a startup company and you are entirely or to a great deal relying on outside firms to develop your technology and your inventions, investors don't like that. They want the engineers in-house. They want to know that there is some control and some value of things being created in the company that doesn't rely on somebody on the outside. I've seen this so many times where the companies did not get funded because they said, you know what? We're not going to take the risk of hiring engineers. We're going to use this outside company to develop this for us. And that's it. And it's to a large extent, especially in hardware things, investors don't like that. So maybe we can do a whole webinar on that. Let's get back into this. I think I've covered all the questions that were relevant to those slides. So leveraging IP to lead markets. So there's licensing revenue, right? You could have, like we were talking, licensing outside technology to other companies. You can license your technology to companies that don't even compete with you, right? Ford Motor Company, that's pretty good. It's pretty obtuse to Hewlett-Packard, where they don't compete directly. There's many variations on that theme. You have exclusive use of technology when you have this intellectual property, when you protect it. And you can leverage in business negotiations and contracts. One good example I have, there's a company, a big European company, energy company, developed, they had this idea, they wanted to collect all of this information from outside smart meters. And they wanted to boil up all that data and mine that data. And they had a blueprint for it. They knew what they wanted to do. They hired an outside company, a startup company, to build it. That startup company just went public not long ago. They took that idea, their blueprint, they had all the intellectual property, and they sold it to this company's competitor. Now, this was a contract issue. They should have foreseen this, but they didn't realize what a competitive edge that gave them, this system. They didn't protect it themselves, that is this company. And this startup company sold it to their competitors, and it was kind of shocking to them. So leveraging that, another way to do that is, okay, we got the blueprint. Let's get some consultants, let's get some internal smart people, put together as much as we can, file a bunch of patents. Then you hire this outside vendor. Now you've got some negotiations to control the sale of this product and the use, especially with your competitors, right? If your competitors are getting it, they should be paying you a price, if nothing else, or at least give you a great head start in the industry because you have this great technology. And it's something that general counsels can raise their hand and say, hey, wait a minute, we're developing this piece of technology. We're contracting the outside, we're giving them the full blueprint. Let's protect it first. It's a modest investment. You can even file provisional applications that are really inexpensive, and you can protect this thing in the short term and then later decide how much you want to invest in wider protection if the thing is really worth protecting. And lastly, collateral for loans. This is relatively new and expanding. Large companies do it all the time. On a large scale, Ford Motor Company, they file 1,000, I think 6,000 or more patents per year. When they want to build a new factory and borrow $4 billion to do that, they go to the World Bank, and one of the questions they ask is, are you innovative? Are you going to be here in 10 years? What's going to keep you ahead of the market? What's going to keep you competitive? And this list of patents is something that they look at. And on a smaller scale, companies are now lending money, almost like convertible, almost like, like debt financing to companies based on their intellectual property. It's this new industry, kind of cottage industry in New York, and they're lending money, non-dilutive money, cash, into their companies based on their intellectual property. So lots of value to be had there. And the value is realized later as you build your portfolio and get patents issued, trade secrets secured, trademarks, etc.
Dave, can I throw in 2 anecdotes on those?
Please, please.
About 2 months ago, my client, startup, no assets to speak of other than a few patent applications, got a $22 million loan based on nothing but intellectual property. The second anecdote is that leverage in negotiations. This was 15, 20 years ago when I was in New York. My client was the biggest company in its market. If you're a specialist in this, you know the company. It's one of those markets that's a gajillion dollars, but you probably don't know the names. But they had formed a joint venture with Citibank to promote a financial services product. My client had all of the good ideas. Citibank, all they provided was the plumbing, the wiring to get money to move from here to there, and just all they brought was that electronic infrastructure. Citibank had lots and lots of patents. My client had the idea. The joint venture, after 2 years, wound up. My client basically had to walk away from this business that they had built with their ideas because Citibank had the patents. And it's one of the big disappointments in my career, but it's a great example of how intellectual property can completely steer a business negotiation.
That's an excellent example of what this energy company should have done. The banks did. They protected their IP and they retained control. They retained control of the product. So it's, time is your enemy. You want to be the one that's protecting these ideas. And you only need enough information so that somebody skilled in the art can build this thing. You don't need to actually build the product, right? So protecting your IP, sooner the better. And the value is, it really is orders of magnitude once you've made a wise investment. Having the holistic approach, having, wise advice and everybody's buy-in, management, legal, engineering, so that everybody agrees what is likely valuable to the business. And it's hard to say that you can't go wrong, but it's the best approach you can have to protecting your IP and eventually realizing value.
Absolutely. Let me, Dave, one quick example of that. If you look
Please.
at leading companies, they really invest wisely in IP. And, it doesn't always make the cover of the Wall Street Journal because for some reason IP makes people snooze, although it shouldn't. But Fast Company, this month's issue of Fast Company is an article on Amazon. And they talk about sort of the operations of Amazon and some of the secrets to their success. And one of the points is about patents. And I was amazed to see that Amazon was granted 2,300 patents last year. It's just an astronomical number of patents, even for a large company. And no one debates that they're an amazingly well-run company, at least from the perspective of generating revenue. So, think about the level of patenting that they're doing. It's amazing. So go ahead, Dave.
Yeah. So we're talking about budgeting too, and as time goes on, you want to manage, and you want to constantly, not constantly, but regularly audit your IP portfolio, because when you leave it alone and you kind of put it on auto drive, you can end up you pay things like maintenance fees. In foreign countries, it's yearly. In the U.S., it's every 3.5, 7, and 10.5. I know it's odd, that many years. But they go really high later because they assume that the patents are more valuable over time. May or may not be true. So you want to look at that, and you could be cutting tens of thousands, if not hundreds of thousands of fat, depending on how big your portfolio is, of IP that either is not valuable to you, or if it's valuable to someone else, you could sell them off. You keep a license, they'll never be used against you, but you could sell them off in areas where the company no longer has interest. So you want to check the cost against the enduring value of this IP. And even though the IP may not serve your company at the time that you're doing this audit, it might be valuable to someone else. And you could, Hewlett Packard, other large companies, they're always even buying and selling off intellectual property in different areas to fill different voids and to, shake off some excess weight. And it actually really pays off quite well. And what's important also is that when you're looking at companies with like divisions that have their own product lines and they have their own separate intellectual property, sometimes they'll want to wind it down and say, you know what, this is no longer profitable anymore, right? Intel even was toying around with making printers way back when they were envious of HP's revenue, right? But it's funny, they'll tell you that the only profit they could get out of it is 40%. And they're so margin spoiled that it wasn't enough return for them. But instead of just closing the area down, intellectual property is the most valuable thing that has, and the people. So if you can keep that bundle, the people and the IP and other assets, you spin that off, you sell it off to somebody who's okay with 40% margins, right? Or something that you're not happy with. They can make it bigger and better. It's good for them. You could sell this thing off for millions. When the patents, you'll be lucky if you sell those off separately, if you get back what it costs to get them. But you can get orders of magnitude when you bundle it together with a product, a division, right? So you don't want to cut those right away and just abandon these things. There's always someone who will be happy to pick through your IP pile and buy the things that are valuable to them.
Yeah, Dave, let me add one more example there, which is more in the trademark and branding category, which is, I think, a very interesting. There's a company out there called Beanstalk in New York, and I happen to know the general counsel of the company. And what they do is they work with established brands to do brand extensions. So things that may not be strategic to your company, but your brand has such power that it could be monetized in other ways. And they'll make arrangements with other companies to help monetize your brand. Like, let's say you're not in the clothing business, but there's that opportunity to monetize your brand in clothing in a tasteful way. That's like found money, right? So there's also other businesses out there that are growing and helping with this whole idea of further monetizing your non-strategic IP, which can be very substantial.
Yeah, and you want to be careful. Whether you sell it off or license it off for other people to help make you more revenue, or if you put it on hold until you're ready to use it later. The one brand I think of is the Hummer. I mean, I remember in San Francisco, Hummers, like when oil was the bad guy, right? I'm not kidding you. I had a friend whose wife would drive into San Francisco in their Hummer, and people would throw food at her. They sold the car because I can't do this. People are yelling and throwing things at me. It was just crazy, right? All it is a pickup truck with a different body on it, right?
Yeah.
But what a great brand. So they just stopped it. They shut it down. No more Hummer, right? And what came out this year? The next branded Hummer. I remember thinking, don't throw that trademark away. It's
Yeah.
such a sign of military strength and integrity and cool car, right? And now it's back. And they maintain that trademark. And it's amazing. Look, it came out, I think it was over 15 years ago. Yeah. Yeah. Really valuable IP. It's good to keep an idea of, points of enduring value, and don't just throw them away. Yeah.
So
auditing is very important.
Go ahead, Dave. Sorry.
Yeah, auditing. I'll hit this briefly, and Chris, you can hit the other points.
Yeah.
Auditing is it's something that you want to have help with outside counsel because they have their hands on these things every day. But you want to keep an eye on and keep internal expertise over what's valuable here. And as the general counsel, your budget is going to start getting whittled away, especially as maintenance fees, they increase over time. So as you're watching them increase and you're writing these checks, you don't want to just leave it to the finance department. They'll be happy to pay these things on time. You want to look at these assets and say, okay, these are not physical buildings that we're staring at or using. If these things are no longer of value to the company, it may not be worth paying that $5,000 maintenance fee that's due next week. Maybe you could sell off this IP to someone or shut it down, right? Rational decisions as you're maintaining this thing, but understanding that an audit really needs to be done. Otherwise, these dusty old things will start sponging money every quarter unless you keep your eye on them.
Absolutely. Yeah. And let's just go to, I'm going to make sure we hit these cost slides because I think these are helpful for GCs and others to keep their eyes focused on them. Maybe I have a rule of thumb that I use, especially with new clients that are sort of learning the IP ropes. And I usually say, when you're talking patents over several years, you're spending tens of thousands of dollars. If you're talking trademarks, you're spending thousands of dollars. Copyrights are hundreds of dollars. And trade secrets are in essence free, although there's an asterisk to that we'll get to on the next slide. And Dave, anything to add to that I want to leave at least sort of 5 minutes for questions.
Yeah, we should. Okay. This is a great thumbnail. I think this is a great thumbnail. Here's a yearly budget projection, which just kind of multiplies the last slide.
Right.
But this is a typical startup company that's 30 or 40 assets, first or second year of operation. You'll see bigger numbers in things like silicon, hardware, because those things get knocked off. It's very litigious. They file more patents, right? But this is just an example where you file 10 patent applications, say they're 10 grand, including the filing fee. By the way, in San Francisco, Silicon Valley, New York, it can be double that. So as a consumer of legal services, keep your eye out for people who are of high quality and of reasonable costs, right? For example, my firm, I have 11 people in Utah. That keeps my costs down. Funny thing is they all live better than I do, but that's how we keep the cost down. You get the same value. You can find that all over the place. In fact, you can find that in accounting, paralegal support, many different areas. So advising the GC, incorporating yourself, being the GC, you can really take advantage of these things, and you can end up doubling the size of your IP portfolio for the same costs. And these are just things to watch out for. International responses to office actions with the patent office. Typically, it takes anywhere from $35,000 to $40,000 to get one patent application through the patent office to issue. And that's in these more expensive firms. And if you're more proactive, I'll give a tip here too. This is inside baseball, okay? If you engage with the patent examiner before they even pick up your file, and it could be a year, it could be 2 years. If you engage with them within, say, 6 months of filing, you have a human conversation with them, talk to them, explain your product, pour your heart out, get your inventor on the line there, right? And this really works. They'll give you better results, and you'll get a better response from them, not just the human part, you'll be educating them, and you'll get a patent issued faster. There'll be less back and forth with the patent office. Typically, for a patent for us, it takes $18,000 to $21,000 to get it through the patent office and issue. It's a huge difference. And the only difference is this phone call that we make
Right.
that starts out the conversation. So there's
Yeah,
the inside baseball tip. And I'm happy to share more details if you want to.
Absolutely. There's
Yeah.
absolutely a human side to the patent agents sitting in the patent office, and that's true of the trademark folks as well. So that is a very good tip. So really quickly on trade secrets, basically.
Can I jump in on that one? Dave,
Sure.
I have never heard that idea before, and I have often wondered about it, but I've never figured out how to manage my calendar. How do I know when to pick up the phone? Because I don't want to call him 2 years before he's going to pick it up, because it'll go in 1 year and out the other.
No.
What do you do?
Well, so I'll just tell you this. When I built Walmart's patent portfolio, I had no reason to believe this was going to work. This is in 2013, 2014. I just started calling examiners. I spent 100 to 150 hours per month. I didn't charge them because I didn't believe this. I had no reason to believe it would work. You got to get in there and do it on a regular basis and learn about the examiners, and all examiners are different. But I will tell you, they welcome that phone call. And if you help them do their job, they'll call you back. And
Yeah, can I have something to add to that, because I actually paid my way through law school doing patent searches for $40 an hour in the old patent office back when it was in Crystal City. And I would meet the patent examiners at the patent office. I'd go in with the invention disclosure, and I'd literally walk the halls and go to the art units and talk to them about, hey, do you have any, I'm doing a search, any ideas about prior art? And those were a great start to relationships. And in fact, when I became a practicing lawyer, I would continue to do that, and go into the patent office and do my own searches. And you really get to know the different art units. I mean, they're people, they want to, it can be boring. They can sit in an office all day, not talking to anyone. So that would be my tip is, it's a little harder to travel these days if you don't happen to be in DC, but that's one thing that can be very valuable, especially if it's a really valuable big client of yours. Make a trip to DC and
oh yeah,
the examiners.
and here's a corollary to that tip. There's a
Yeah.
corollary to that tip. If you go talk to the examiner, if you have an inventor that's presentable, right, that will talk, be rational, talk to the examiner, and they will eat it up. They love meeting with inventors. Do it over the phone too, or in person, right?
Yep, and even I don't know, they might even Zoom these days with you. So
yeah.
So that I haven't tried that with examiners, but I wouldn't be surprised if you could. So really quick, because we're just about out of time, apologies, but a trade secret is very broad, right? It's anything that has value to your company and to others because it is being kept secret, right? So it is important to document, as Dave already discussed recently, and fairly recently in 2016, trade secrets were federalized. That's always a good sign that an asset class is ready for prime time, right? Way back when securities were federalized, et cetera. This is a sign that trade secrets are about to hit the big time, right? So it is really important. They are cost-free. There is there's no registration process with the government. So in a sense, they're cost-free, although obviously you need to set up your operation and management to identify, protect, and monetize your trade secrets, right? And it's anything from making sure you do NDAs whenever you're dealing with someone outside your company who touches your trade secrets, to actively promoting your technical side of your business to understand what trade secrets are and to recognize their value so that they don't just spill it all having coffee at Starbucks with engineers from other companies. I call it the double bonus. One thing that's really interesting is the flip side of trade secrets are that the same information that's incredibly valuable to your company because it's a trade secret are also incredibly valuable to evil hackers that are out there that want to access that data and sell it or use it to ransom you. And this stuff happens all the time. I know a lot of cybersecurity lawyers. This stuff happens all the time. So if you're out there as the lawyer for the company, helping them find the trade secrets, you're also finding cybersecurity risks. And this is really important. So remember that image of the coin. You're monetizing the trade secrets on one side, but you're avoiding losses due to cybersecurity risk on the other side. We're back to that upside downside risk that we started the discussion with. I think we're just about at the end. Yeah, there we go. So there's our contact information. I also posted it at the beginning in the chat window. So let me stop the share. And then I'm also going to unhighlight us. And yeah, we could probably have a little bit of an after party here. I could stay a little bit later if people want, since we ran out
I'm
of
good. We have
time.
17 people. One
Yep.
question that I just quickly answered while you were talking was selling patents. And
Right.
brokers often what they'll do is they'll stack your patents on their shelf and offer them for sale when they see opportunities. Best way to sell patents is to be involved yourself and find potential companies that could use them, especially large companies. They always have voids, things they need. And if there are patents that you want to sell off for whatever reason, it's good to take that close analysis and work through a trusted middle person to do that. We do it all the time. If you have any questions specifically about that, Roger was asking the question, reach out to me and I can give you some ideas based on whatever your situation happens to be with your IP.
Absolutely. And if you Google the story of Texas Instruments and how they monetized their patent portfolio a couple of decades ago, absolutely incredible story. I met and worked with the guy who did that, and it was an absolutely amazing story of how they transformed the fortunes of a company. So if you think of Texas Instruments just as the company that makes calculators, you're missing out on the biggest part of the story. So
you'll never
let's
see
wrap
something
up.
that's sophisticated. I mean,
Yeah.
Texas Instruments, back in '97, I was working for a client. They were doing these educational toys. You know, you have this animal, you press the Z, find the letter Z. Yay, you found the letter Z, that kind of thing, right? Well, there are TI chips that run that thing. And when you purchase TI chips, they've got this patent portfolio of child games. I'm not kidding you. And when you buy that chip, if you infringe like all of their patents, you're going to pay like, I think it was like $15 for the chip. But if you cut away the features that are claimed in those patents, it drops it down to as little as $5, right? They did this so that the people that were getting the most value out of their chips would pay more for their chips. Incredible what TI did.
It's amazing. So let's wrap up the recording, Dave. I want to thank you, Dave Stevens. He's out in Silicon Valley. He does all kinds of work in the IP area, especially patent prosecution. I've known him for years. I encourage you to reach out to him if you have any questions. I'm more in the IP litigation space, and also as my night and weekend job, I run PARC. So you can find us at parclegal.org. PARC is with a C, parclegal.org. And you can also reach me, Chris, at parclegal.org. So let me stop the recording, and then anyone who wants to stay and ask some questions sort of off the record, happy to have you stay.